Welcome back to a new deep dive. Today we have, kind of a wild mission.
Yeah.
We are uncovering the hidden, highly optimized financial ecosystem operating right beneath the surface of the California criminal justice system.
Yeah, and we're using Orange County as our main lens for this today. It's a really fascinating structural system when you look closely at it.
Exactly. And we're going to start with this 2016 case study. So a guy named he posted a $10,000 bond, but then the complaint was literally marked missing compil in the system.
Right, which basically means it was dropped for a total lack of evidence.
Okay, let's unpack this. If those charges just vanish, you would think he immediately gets a check for 10 grand in the mail, right?
I mean, you would definitely think so, yeah. Since no charges were filed, that money really should be returned under the Penal Code 1303 15-day exoneration window.
Right, he gets 15 days.
But, and this is the catch, the burden is entirely on the defendant to claim it. The court isn't going to remind you. And what's fascinating here is, if that money sits unclaimed for 3 years, this thing called Government Code 5050 triggers escheatment.
Escheatment, which is just a fancy legal word for the government taking it.
Yeah, pretty much. It legally transfers those funds directly into the county general fund, permanently.
Wait, so it's basically like a gym membership that takes one click to join, but then requires you to, mail a notarized letter and a blood sample to cancel.
That is a shockingly accurate analogy, actually.
Because to reclaim this money, you need notarized forms and historical proof matching the address on file. That creates insurmountable friction for everyday people.
Oh, absolutely. And, that bureaucratic friction gets exponentially worse when you factor in the language barrier. There is a severe shortage of certified court interpreters in California.
Right, so if you don't speak English well, navigating those forms is just a complete nightmare.
Exactly. And courts actually use this good cause loophole to bring in uncertified interpreters just to keep things moving. There's even a legal precedent, King v. Lee, where swearing in an uncertified interpreter is just considered a harmless error.
A harmless error. But doesn't that lead to, massive mistakes in the courtroom?
Oh, huge mistakes. I mean, one of our sources documents a case where a minor traffic dispute was literally translated into an admission of rape.
Oh, wow. Wait, really?
Yeah, it's really that bad.
So let me get this straight. Marginalized defendants literally cannot understand their right to a refund, ensuring their bail money just quietly flows directly back to the municipal agencies that arrested them in the first place.
Yeah, that's exactly what happens.
I mean, that is a massive systemic conflict of interest. But let's say they somehow get past all that. If the charge was dropped for missing evidence, they at least walk away with a clean slate, right?
Unfortunately, no. A dismissed charge doesn't erase your permanent arrest record.
Right. It still pops up on background checks.
Exactly. To actually clear it, you have to formally prove your factual innocence under Penal Code 851.8, which is an almost impossible burden.
Why is it so hard, though? If the court already admitted the evidence was missing.
Because if a judge officially declares you factually innocent, it immediately opens the county up to massive civil lawsuits for wrongful arrest.
Oh, wow. I see.
Yeah. So the Orange County Conviction Integrity Unit, the CIU, has a literal 0% exoneration rate for factual innocence. They prefer quiet, behind closed doors, case adjustments to shield their municipal liability.
So they are protecting their funds from lawsuits on the back end. But looking at our sources, they are also aggressively generating new revenue on the front end, right?
Right.
Through state grants.
You got it. Under state laws like SB 678 and AB 109, counties get millions of dollars for keeping their probation failure rates low.
Which sounds great on paper, but
it leads to this crazy jurisdictional arbitrage. Orange and San Bernardino counties use Penal Code 1203.9 to transfer compliant, low-risk probationers back and forth between each other.
Wait, they transfer people?
Yeah. If we connect this to the bigger picture, they are literally trading human successes to artificially boost their metrics and win more state grants.
That is wild. They're trading people like baseball cards. And the budget disparity driving this is glaring. The sheriff requests about 55% of those AB 109 funds, while the public defender gets just 1.7%.
Exactly. It completely starves the defense.
Which forces these rapid plea deals because public defenders are overwhelmed, and that just feeds people right back into this exact same probation machine.
It is a perfectly closed loop, yeah. The justice system here isn't just adjudicating laws anymore. It's capturing capital, shielding liability, and gamifying human statistics.
So what does this all mean? I mean, it seems like true reform has to involve uncoupling county revenue from conviction and probation metrics entirely.
Absolutely. Until you remove the financial incentive, the system will keep optimizing for revenue.
Well, that leaves you with this to think about. If a local government's operational budget fundamentally relies on the financial penalties and statistical manipulation of its own citizens, is it structurally possible for that municipality to pursue true, objective public safety? Or are they just managing a very lucrative portfolio? We'll leave you to explore that on your own. See you next time on The Deep Dive.